to our Blind Professor's Lecture Series, otherwise known as Michael's Lecture Series. Today, Michael will be considering the contentions, controversies, and questions arising from the evolution in contemporary international law. This lecture is taken from his book titled Resolving the Unsolved Questions and Contentions in International Law. I remain Miss Jeannie Chakamweze, your anchor person. So shall we listen to our blind professor now?
Right. Thank you, everybody. Thank you for having me. I'm sure you heard my uncle person. I call her British Beauty, right? And you've actually seen that, haven't you? Yes. She introduced that I'm coming to talk about contentions, controversies, questions, counter questions in international law. Okay, she's correct. But I want to introduce somebody to you before this lecture. A very strange lady I want to introduce to you. She's by my side here, she's with me. You can't see her until I introduce her to you. The biblical account tells us about a man, Jesus Christ, who was born without an earthly father. This is what I mean. He's got a heavenly father, but not an earthly father. What that means, in certain senses, is that Jesus, the Lord Jesus, defied DNA. This lady I'm here to tell you is another lady who has defied every sense of DNA and what have you. How do I mean? I told you she's very strange. She's got, number one, as part of her strangeness, 5 fathers. She's born by 5 fathers. Number 2, strangeness, she has got no mother. Number 3, she has got over 193 suitors all over the world. Isn't that a strange lady? Really, really, so you will say. And you know what? One more thing about her. She's having romance with all the over 193 suitors. Her name is International. All right, so our discourse is on international law. And where do I begin? Elementary science will tell us that international law deals with the romance between nations. Further international law will tell us a further definition or further elementary science about international law will tell us that international law is a composition of 3 words. The words inter, nation, and law. The word inter, to begin with, is a Latin word, which means between or among. And of course, you know the definition of nations is territorial boundaries, of course, arising from de jure recognition or even sometimes de facto recognition. And law, already my panelists, you know, law is a body of rules and obligations binding on individuals, on institutions, and what have you. All right. But viewed more deeply, public international law, commonly referred to as international law, is a body of laws which governs the relationships between and among entities with international legal personality. Such persons, or such legal persons, include sovereign states and other international actors, such as international institutions, intergovernmental organizations, and in more modern times, natural persons. I mean, individual natural persons. The legal personality attributed to these entities means that they have rights, protections, interests, responsibilities, and liabilities under international law. International law flourished more from the wake of the end of World War II in 1945, and much more in the aftermath of the Cold War spanning from 1947 to 1991, thereby broadening in scope, deepening in content, and embracing a focus on novel subjects as individuals, as I mentioned. Individuals are the more modern subjects of international law. The Cold War was between two blocks, the Eastern Bloc and the Western Bloc. But that came to an end as far back as 1991. But many things have developed since then. While this period furthered many governance projects envisaged in the post-1945 settlements and resettlements, shifting power and rising nationalism now suggests that the arrival of a more difficult phase for international law has become a reality. It will therefore be argued that in the coming years, and even beyond, areas of the law perceived by some as too liberal will become more vulnerable to attacks, reforms, and consequently inevitable changes. Thus, tensions will persist between key states on how the law applies to emerging global challenges. Such a conclusion as this may be perceived as the prediction of prophetic doom. But the reality, however, is that the reality remains unchanging, that evolutionary changes in both developmental and counter-developmental phases cannot but remain unceasing. Hence, it does not fall to any argument in solitude that one embracing the generality of constant instances of incontestable realities that questions and contend with developmental changes in international law, international moratorium, international recriminations, influencing rhetorics, and sweeping maneuvers in the quest for a better world will doubtlessly continue. Now, the point being made is this: because international law is evolving, and it does continue to do so, the definitions will continue to change with time, and events will continue to dictate the pace of the arising issues in international law. So much to say. Well, the book Resolving the Unsolved Questions and Contentions in International Law addressed a number of topics. I'm not going to go through them. 12 chapters actually. Part of them include matters of statehood, matters of legitimacy and impartiality in international law, which I'll come to very quickly. And then other issues of human rights, issues of jurisdiction, matters concerning past and modern definitions of international law. And there are other contentious issues, such as which is of the more potent and binding force between the decisions, the resolutions by the UN General Assembly and the UN Security Council. And a case in point, the case of Mauritius, deals with that adequately. Matters about the International Court of Justice, contentions between treaties and customary international law, and oftentimes the academic question of supremacy of the two is discussed in the book, and the cases of Barcelona Traction and North Sea Continental Shelf is adequately addressed, discussed here in order to answer those contentions. Other contentions and questions, counter questions are well elucidated in this book. There is also a novel issue from the European axis, also discussed in this book. That has to do with the EU General Data Protection Regulation, which was formulated in 2018. It's about jurisdiction. Generally speaking, citizenship is well tied with jurisdiction, because the jurisdiction of everyone is like one's following shadow. Your jurisdiction goes everywhere with you. But that regulation, I mean the GDPR, the General Data Protection Regulation by the EU, seems to have redefined what jurisdiction is now about, because it has now extended its ambit beyond citizenship to cover questions, issues surrounding residency. The crux of that, or the concern of that, is it seems, and not really seems, it has stretched its frontiers into concerns of international law, because it now seems to speak the language of extraterritoriality, of jurisdiction. And that is raising many questions and contentions in international law. I mentioned earlier the issue regarding legitimacy and impartiality of international law and some of its institutions, especially the International Criminal Court. And many have argued that international law is no law at all. They posit, some of them posit that, well, there is no legislative arm, there is no separation of powers. Some go as far as saying, well, the word of the 5 permanent members of the United Nations is law, and that appears to be short of anything, lacking any democratic values, and is such that seems to be embracing a dictatorial system. Others argue in the other direction, that, well, whether or not there is a legislative arm will not be potent enough to nullify the legitimacy of international law. International law remains law and remains the regulation regulating the reciprocal relationship among nations, among international organizations, among international institutions. And they base their position on the fact of the success that has been attained by international law over the years, especially since inception after the Second World War in 1945. Others have also gone further and argued that even the institutions of international law that are tools being used to regulate affairs between states, it's in question. For example, the International Criminal Court, and their argument also is on legitimacy and particularly impartiality. They argue that the first 20 years of the existence of the International Criminal Court is such that has been seriously partial because its searchlight, as they argue, has been beamed on African political leaders only. And true to their word, my panelists will agree with me that the ICC has issued warrants of arrest and taken steps against some African leaders. An example is Uhuru Kenyatta of Kenya. Another is the former leader in Sudan. Well, the two of them former leaders anyway, because Uhuru is there's a new leader in Kenya now. Omar al-Bashir of North Sudan. They've also referred to Laurent Gbagbo of Côte d'Ivoire in his days, and somehow, although the International Criminal Court isn't responsible for that of Charles Taylor, Charles Gange Taylor of Liberia, but it is still international law in many senses that is at play. And they argue further that why is it that the International Criminal Court was unable to do anything, even at the investigatory level, about the misdeeds in Venezuela, the British American soldiers' activities in Iraq, and all that. It seems to suggest, the arguments seem to suggest that the big players are untouchable by the International Criminal Court. And it appears their position follows the line of thought by Tracy Marcus, who said, law in any sense is nothing else but an interest of the strong. And many more arguments that school of thought has posited against international law, against its institution, such as the International Criminal Court. Of course, the International Court of Justice is not left out of their criticism. Article 46, the moratorium on no review of judgments, and some have even pointed finger on the no compulsory jurisdiction of the ICJ, following Article 36, that the ICJ should be able to have the power to compel states, you see, and its judgment should be reviewed. And some have even queried some of the judgments of the International Court of Justice and saying it runs short of what truly in legal sense should be law, which should be the only avenue for the dispensation of justice. An example, one case cited in this instance is the Nigeria-Cameroon case. I'm sure we remember that. Critics of the International Court of Justice in that respect have said, well, something was missing. Something was not given attention by the International Court of Justice. And that was an international instrument, an international tool known as plebiscite, which they feel should have been used. What's plebiscite? Plebiscite is kind of a referendum that the court could use, especially in matters affecting a large population of people. It's often used in determining matters of national importance. In other words, the people of Bakassi should have been consulted as to which of the two countries they want to belong to. After all, right to self-determination is an issue known to international law. And why was that not a consideration? Was it that the big players like France influenced certain things, just questions, counter-questions, contentions, arguments, counter-arguments, back and forth. Anyway, in summary, the possibility that one unanswered question will birth many more questions and contentions is oftentimes a certainty, not a rarity when it comes to the issue of international law. But let's bear this in mind, that the oneness of the international system, designed with a focus for the three causes of human affairs, human feelings, and humane facts, born out of objectivity, defaces inhumanity, and thus solves most problems and contentions. But when the coinage and the practices of international law and international institutions, which remain the cornerstones of the international system, shifts from these three causes, thereby ceding space and reflecting the dynamics of an unequal community of nations, then questions surrounding the legitimacy of international law will arise and continue to subsist. Nevertheless, the legitimacy of international law and international institutions cannot be discountenanced or defeated simply because lawmaking processes lack legislative branches, or because of the absence of separation of power, or because it appears that the 5 member nations making up the UN Security Council seem to be dictating the pace. The truth is, there must be one at the head to direct the affairs downward. Successes of international law and international institutions overseeing the affairs of the international system. Unarguably, so much remains undone and beckoning for attention. But it is pertinently worth noting that outcomes remain the sole proof of inputs, just as eventual success is the evidence of effort. Our world is undoubtedly largely peaceful in more modern era because the international system has translated the willful effort and the actions of international institutions and the transnational laws which ensure safety, which decry crimes of egregious kinds, and which ensure human security, human rights protection, and international peace into such a coordinated arrangement which now informs us more that our world and the relationships we share with one another are such which must continue to embrace humanistic ethos in humanity's kingdom and not the anarchies prevalent in an animal kingdom. I wonder what the world will look like without international law. So you see why international law has a romance with over 193 nations of the world. You tell me what a special lady that must be. That must be, you know. The world will not do without international law. I thank you for your attention. But before I go, I have 2 more things to say. Permit me, my dear panelists. And number 1 is this. This YouTube channel welcomes your research questions, which will help to birth more lectures. So please send in your comments and questions, and it will help us further. Second, well, while nations of the world are continuing with their romance with this specially pretty lady called international law. You don't think I need to go myself because I have a brand of international law in my house? And it would be good for me to woo her tonight with a second toast. The first toast led to our marriage. I'm here with wine for her today. And what do you think? It's going to be a wonderful romance later tonight. Thank you so much. Thank you, everybody.
For an insightful overview into your book. If you would like to know more about international law, some of the unanswered questions, please purchase our book. It's available on Amazon for you to have all your answered questions. Thank you.